Did you know? Inmates can be charged for the cost of their incarceration. In Michigan, MCL 801.3131A allows for up to $60 per day.
Good morning, Your Honor. Kathy Kakish, Assistant Attorney General for the State Treasurer.
Thank you. State Treasurer versus Michael Keranen and the University of Michigan Credit Union. File number 23-105-839-CZ. Time and date set for show cause hearing. Ms. Kakish appears and Mr. Keranen appears. Counsel, you may proceed.
Yes, Your Honor. As indicated, this is the time and date for the show cause hearing that is being held under the SCAPRA, which is the State Correctional Facility Reimbursement Act. I did submit a show cause hearing brief with 3 exhibits, and Mr. Keranen was served with the brief and the 3 exhibits, and a copy to the court was provided. Your Honor, in sum, what I have to say is basically what is in my brief, and that is going through the points for the SCAPRA hearing. First of all, Mr. Keranen is a state prisoner, and he is subject to the jurisdiction of the Michigan Department of Corrections. He's been sentenced to a term of imprisonment where his earliest release date is March 27, 2033. And his maximum release date is in June 2052. Now, this court does have jurisdiction over the matter because it is the Huron County Circuit Court is the sentencing court for the underlying criminal conviction. Now, under Michigan law, Mr. Keranen is indebted to the state for his cost of care. His cost of care through his earliest release date within the next 10 years, his earliest release date is in 2033. The cost of care is in the amount of $421,560. And attached to our brief is exhibit number 1, which is an affidavit from the Michigan Department of Corrections, which provides a breakdown for this cost. Now,
Ms. Kakish, what does that break down to in amount per year?
It really does not break down to amounts per year. It goes by the per capita payment of each facility per year. So they go to the facility and they go to see how much it costs for that facility when he was there at that particular facility. So basically, every single prison facility has its own costs per year. Now, we don't have, every year things, the costs are different, Your Honor. So they calculated by the year in which he was in that particular prison. Now, having said that, the affidavit of cost of care uses the final 2021 per capita figures. So that means the costs for 2021 are actual, but the costs for 2022 onwards are estimated costs. And of course, as time moves, we know that the costs will increase. So if he were to stay in prison through his maximum release date in 2052, we're looking at $1.2 million. But we definitely know that his earliest release date is 10 years away from now in the amount of $250,000.
By this point, you're probably screaming at me asking what he's in for. I wasn't able to find the actual docket, but I did find a couple news articles related to the original incident. And it appears that Mr. Keranen was charged with OWI, operating while intoxicated, stemming from an automobile accident that happened back in 2022. He was driving just after 10 p.m. on June 25th in Hume, H-U-M-E Township, when he ran a stop sign and collided with a Yamaha motorcycle being driven by a 32-year-old father of 6. Tragic. Unfortunately, the motorcycle driver did not survive the accident, and Mr. Keranen and his passenger were severely injured. He was charged with 1 count of OWI causing death, which could earn a prison sentence of up to 15 years, a second charge of OWI, which could add 1 to 5 years, and then his habitual offender status could possibly double the maximum sentence. And the reason he has a habitual offender status is that he has 5 previous OWIs. This actually makes his 6th.
Now, Mr. Karinen has 2 assets. The first asset is an immediate asset in terms of cash, and that is found in the University of Michigan Credit Union bank account, where it currently stands at $32,000. Now, the money flows into that account on a monthly basis in terms of pension payments from the Nationwide Retirement Solutions, Inc. Now, he currently has 401A and 457B accounts with Genesee County that are managed by Nationwide. The total amount currently standing in those 2 funds, which are governmental private funds, is $679,000, depending on the fluctuation of the exchange market. Now, to the historical procedure, the facts of this case, on January 9th, 2023, this court entered an ex parte order which freezes the money flowing into the bank. It freezes the bank account itself. So the money is continued to flow into the account, but the account itself is frozen. And then later on in March, the state treasurer learned that the 2 retirement accounts are actually government accounts, not 401k accounts. 401k accounts are usually protected by ERISA. Government accounts are not. So that's when we learned about the nature of the accounts, we filed an amended complaint, and we named Nationwide as a defendant. Why? Because we really need to know from Nationwide if there's going to be penalties and the amount of taxes for going into these accounts. That we will discuss that further on in the brief. However, the ex parte order directs Mr. Karinen, in the event that if he does not hire an attorney, to send in writing to this court and to the Department of Attorney General any written objections he may have against this entire case. We have not received any written objection from Mr. Karinen. Having said that, though, we are aware of the fact that he is objecting to the disbursement of any funds to the state of Michigan, and his argument will be related to the second issue in our brief, which is related to preferring creditors over his obligation to pay towards his cost of incarceration care. Now, there's no doubt that the funds in this case are SCAFRA assets, specifically that, as I mentioned, these funds are not protected by ERISA. They are governmental funds. So that is one issue. But the main issue, as I said, was that Mr. Karinen believes that the money, he has a house, and he wants to maintain that house, understandably. But we're looking at the next 10 years. His adult daughter, upon information and belief, lives in that house rent-free. So he wants his monies to be paid towards his mortgage to the house. That's my understanding of what his argument may be. But Your Honor, SCAFRA is very clear that, and the Court of Appeals and the Michigan Supreme Court, they made it exceptionally clear. And I listed various case names by these 2 courts in our brief. They made it very clear that a prisoner cannot prefer creditors over and above his statutory duty to pay towards his cost of incarceration care. Specifically, the Michigan Court of Appeals in Shaco, which is listed in our brief, 218 MISH-App 185, entered in 1996, specifically said that they are not going to entertain anything related to a prisoner preferring creditors over their statutory obligation to pay creditors. So that's our information with respect to his argument. The only defenses that a prisoner has under the SCAFRA, generally speaking, are defenses that a court, a circuit court under the SCAFRA must take into consideration. And therefore, that's the third issue in our brief. The Court of Appeals has made it very clear that every single circuit court reviewing a SCAFRA case needs to take into consideration the legal or moral obligation of a defendant towards his minor child, spouse, or dependent. And that statute is basically one very long sentence. It reads from MCL 800.404, paragraph 5, and it reads.
I read it. You go get right to it.
MCL 800-404, paragraph 5 states, at the hearing on the complaint and order and before entering any order on behalf of the state against the defendant, the court shall take into consideration any legal obligation of the defendant to support a spouse, minor child, or other dependents, and any moral obligation to support dependents to whom the defendant is providing or has in fact provided support.
In conclusion, upon information and belief, Mr. Keranen is not married and he does not have any minor child or dependent. So, Your Honor, we are asking that he does have he does have assets that cover his full cost of incarceration care. In exhibit number 3, we submitted a proposed order. We're asking for the full cost of care. We're asking for a portion from the bank and the remaining portion to be taken from the funds. Thank you.
You're welcome. I've just been advised that Nationwide is.
Hello,
Please state your name.
my name is Sonia Curran. I represent Nationwide.
SANIYAKHARE.
Yes, Your Honor. I apologize. I've been trying to join the live stream since 9 o'clock, and it kept saying host is in there. We'll let you know to let you in.
Sounds like you have insufficient bandwidth because we're having problems. We're having problems hearing you, but you may proceed.
Can you hear me, Your Honor?
Yes, I can.
Okay. I apologize for the delay. I have been waiting in the Zoom host room, and for some reason it just now let me in, but I did have a chance to watch some of Miss Pakish, am I pronouncing your name correctly? Some of her statements on the YouTube live stream. But I'm counsel for Nationwide, and our position basically is that, we would like to pay in accordance to the plan documents. And, currently we are not paying anything right now, but what we would like, since the participant and the state have the same claim, we will pay as the court directs, but we would like the court to issue an injunction to both the participant and the state, so they cannot file suit against us once that decision has been made. And we are just waiting to pay in accordance with the plan documents. We're waiting on the plan documents. Get the plan documents, we will review and see if a lump sum payment can even be made per the plan documents. And once the court issues a decision on, who needs to be paid, and it's in accordance with the how, which is the plan documents, we'll probably seek a motion for interpleader under 3.603 and pay in accordance with what the court would like.
Very well, thank you. Excuse me, Mr. Kieran, your response.
Basically, I went through the documents Nationwide gave me. They said that they're basically said with my age and the type of accounts I have, the payments can be made. The only concerns I have is that the rate amount of taxation is taken out of the funds. So I do not have obligation to the state of Michigan or the federal government on the amount that's distributed, because those funds are taken pre-tax, and show tax will have to be taken out when there's a disbursement.
Thank you. Ms. Kakish, again, final argument and your response to a request for injunction as well as the comments made by Mr. Keranen.
Yes, Your Honor. With respect to the injunction, I do not understand. I heard the word interpleader. I didn't understand where that came from, but Nationwide is named as a defendant. So we don't know where the interpleader is coming from. With respect to the injunction, Your Honor, that is easily resolved. Normally, Nationwide did receive a copy of this show cause hearing brief and a copy of the final order. Usually what will happen is that somebody from Nationwide or their attorney would contact us to add and ask to see if they can add language to the final order. Unfortunately, it did not happen in this case. What we can add is a paragraph indicating that Nationwide shall not be held liable in implementing the terms of this of the final order. With respect to taxes, Your Honor, generally speaking, taxes are covered by prisoners because an asset is usually what a prisoner has. And we usually take from what is available. Taxes are usually paid out, are taken before a prisoner receives his assets. In this case, yes, I did contact Nationwide. I was unaware at the time that Ms. Kerr was representing them, and Nationwide did not inform me that they had counsel, and that was back on Monday. I did contact Nationwide and ask them two questions. One, what the penalties would be for withdrawal, and two, what the taxes would be for withdrawing. I received documents from them, and those are the documents that I sent to the litigation coordinator at the prison, who handed them over to Mr. Keranen. I believe it was delivered yesterday or the day before. And that's where Nationwide indicated that there is no penalties either for the state or the federal government. What we're looking at are taxes. The taxes are 20% for the federal government and 4.25% for the state. So I calculated it. We are asking for $393,000 and $393,000 from those two funds. If we calculate the 24.25%, the 20% from the federal and the 4.25% for the state, that means a total of $95,317 are the amount of taxes. Mr. Keranen has almost $700,000. There still will be funds left for him, Your Honor. Thank you.
All right, the court has heard the respective arguments of counsel as well as pro se defendant in this case. Based upon what the court has heard and the issue before the court as well is, and the court has to consider the legal or moral obligation of a defendant toward a minor child, spouse, or dependent. There is no minor child, spouse, or dependent in this case, and as a result, the court will grant the relief requested by the state in this matter. And I will require that the language that Ms. Kakish just mentioned a moment ago be added relative to the liability aspect of Nationwide. And that will conclude the proceedings, but Ms. Kakish, you have to submit an order to, actually you did submit an order to the court, correct?
Correct, Your Honor. But as indicated, that sentence needs to be added.
Yes, so I'll allow you to submit a supplemental order to the court for the court to sign. And can that be done within 7 days?
Oh, yes, Your Honor. I would contact Ms. Carey so that she would approve that language because they tend to use a lot of legalese languages in such order. So I'd get her approval. And yes, I can submit it under the 7-day order, or I can email it to the court.
Whatever works best for counsel in this case. That'll
Thank you.
conclude it.
Thank you.